All right, welcome to the Disability Law Show, and welcome to all our viewers in Ontario and BC and Alberta. Good to have you along. Stick around for the next 30 minutes. Lots of information for you to glean from this show. Again, James Fireman going to be co-hosting with myself. Anytime, by the way, you want to check more information on disability law, there's part of that in the pocketemploymentlawyer.ca. That is a employment law website, but there's a big, robust section on disability law. You can go there anytime you like. The phone number, 1-855-821-5900, help@disability rights is where we're going to pull the emails from today, as we always do. And James, coming up on the show today as well, 3 mistakes people make when they are denied LTD, long-term disability. That is on the way. We're busy, but the week that was is first, pal. What do you got?
Well, I want to talk to you about a case that I recently resolved, and one of the things that is a theme on this show every week, it seems, is appealing. So if you are denied a long-term disability benefits claim, or you are getting your benefits and then they cut you off, the insurer is always going to give you the option to appeal. They'll send you a letter and it will set out, usually in pretty vague terms, why they've decided to deny or cut off your claim. And at the end of that letter, there'll be an invitation to appeal their decision. Well, what this really is asking you to continue to allow them to set all the rules and make all the decisions. And there's no reason that you have to do that. Because when you do that, obviously you are giving the insurance company complete control over the process. If they have denied your claim or cut off your benefits, you can start a legal claim, and that will take control entirely away from the insurer. So this case that I recently had, it's a construction worker that suffered, well, it was really a back injury that was over years, just got worse and worse. It was a progressive injury, and it got to a point where he was no longer able to continue working. And this was universally accepted by his treating doctors. He had a family doctor, an orthopedic surgeon, he had a therapist. All of them were in agreement this is not someone who was going to be able to continue working. And so he applied for benefits. He was eventually actually approved, but then after about a year or so, they cut him off, and they said that they would pay him up to this 2-year mark, the change of definition, but after that, he was going to be able to go back to some other occupation. Now, this was obviously not something that was going to be medically justified. They actually had no doctors that said this, but more to the point, he was someone who had worked in construction virtually his entire life, had no post-secondary education, had no ability to use a computer other than sending a couple of brief emails. This isn't someone that was going to be able to find a job. And his wife, who worked in an administrative position, thought, okay, well, I'm going to go and I'm going to do this appeal. I know how to do paperwork. And, you know, she thought she was doing the right thing, of course. And so she appealed when he was cut off, and that was denied. And so she just figured, well, you know, maybe they just don't get it. So I can appeal again. And she did. And again, it was denied. Then she appealed again, and it was denied again. In fact, she appealed 5 separate times on her husband's behalf, and every single time, even with new information provided by her husband's treating doctors on each appeal, they just continued to deny that claim. And so eventually she decided, well, you know what, maybe I need some help. And so she gave me a call. We managed to get that claim resolved in 7 months. We got to a mediation in 7 months, and they paid him almost 15 years worth of future benefits, including everything that they owed him up to the date of that mediation. So it was obviously a huge success for them. They were ready to write off the entire thing because they were so frustrated with the process. And it's all because there is this imbalance. When you are dealing with an insurance company and you're playing by their rules, it's really unfair. They have all the resources, they're making up the rules, and they are the ones who are making the decision at the end. As long as you continue to appeal, that's the way it works. If you start a legal claim, all of a sudden, they have to be reasonable. And that's exactly what happened.
Yeah, it kind of seems like people assume that an appeal is something that goes to some sort of federal or provincial body outside of the insurance company.
Yeah, it doesn't at all. It usually goes to the same adjuster that made the decision in the first place. Right. And if they're being real fancy, maybe they give it to their direct supervisor. But it isn't going to someone who is independent in the process. It's going to someone within the insurance company, which means it's going to someone that has the same motivation to make money for their employer. And that's what insurance companies are in the business for. There's no point in beating around the bush or pretending it's something else. They're in the business to make money for the shareholders. And you have to understand that. Insurance companies have a motivation to cut you off or to deny your benefits as soon as possible. And because of that, their employees have that very same motivation when they are adjudicating your cases.
Generally, when someone is cut off their LTD, their long-term disability insurance, they have a 2-year window to bring about a claim with you. Does that appeal process, I know it's a gray area whether that appeal actually resets the clock, but if it doesn't, you could be in real trouble, especially if you go for 5 appeals, right? You might run out of time.
Yeah, in this case, my client was very fortunate. I mean, he had used up a good chunk of that 2-year window, but enough was still left over that we were able to get the file and start the claim in time. But that is really what the insurance company is banking on. They're banking on running out that 2-year clock. As soon as they deny your claim, the very first time a clock starts running. And the law isn't clear on this. It's gone back and forth over the last couple of years, but you don't want to take your chances with it. And so once you've been denied that first time, you should assume that the clock has started running. And if it runs for 2 years and you haven't started a legal claim, sorry, you're out of luck. You're not going to be able to challenge that claim anymore. No court is going to accept that you are able to bring a claim in that circumstance. So you need to start it within that 2-year window.
DisabilityRights.ca is the website. You can go there for more information on what we talk about on the show and links to our radio show as well. James, as you know, we've done this in the past. We like to play some of the phone calls we get from our radio show here, and we talk about them. First call for the day is coming up right now.
Yeah, my wife she was off. She broke her arm, and she was on her benefit plan through work in March, and she was on benefits till July. But she was supposed to have benefits till September, but for some reason the insurance company benefit plan says that she should have went back to work like on a limited basis because of what she can lift. Employer doesn't agree with that. What do I do?
Well, so this is a bit of an interesting scenario here. So if you are disabled, you're off work and you're getting your benefits, if you are well enough to return to work on a modified basis and your employer is prepared to accommodate that modification, whatever it is, whether it's avoiding lifting heavy objects or whether it's reducing your work hours, at least initially, whatever that modification is, if your employer is in a position and is prepared to offer a modified employment role for you, then your insurer would be justified in saying, okay, well, this is available for you. Your doctors are saying that these modifications are appropriate for you, and that would be a justification for your insurer in that case, saying, okay, we're not going to continue paying benefits. But it isn't up to the insurer to say that, it's up to the employer. And there are many positions where an employer would be quite justified in not making an accommodation if it's just unreasonable for them to do it. There are situations where it's just not reasonable to accommodate someone who can't lift something of a certain height. If your job is entirely about lifting and they don't have administrative positions that they could put you in or that you would be qualified for, an employer in that situation, I'm sure, would be justified in saying, I'm sorry, we just can't accommodate until this person is no longer disabled. And if that is what the employer is saying, and it seems to be in this case, then the insurer is in no position to say, oh, well, you have to go back on a modified basis if the employer isn't even offering that. In that scenario, the insurance company's on the hook. Sorry, they're going to have to pay those benefits. And if they take the position that they don't, then it's what we call low-hanging fruit. You start a legal claim and they'll pay up.
3 mistakes people make when they are denied LTD. That we will tackle, but after a short break. You'll want to reach out, 1-855-821-5900. Email is help@disabilityrights.ca. It's a disability law show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurance to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Thanks for sticking around. Disability Law Show. John Scholes along with James Fireman. James, I know you want to drill down on each of these 3 mistakes people make when they are denied long-term disability. Number one is this: they seek advice from people who are, we'll call them ill-informed. Your neighbor Steve or Google Law School, something like that, right?
Sure, and it can come in many forms. So a lot of times people will get some advice from their doctor that they should do one thing or another. On a previous show, we had a doctor tell someone that, well, they weren't totally disabled, so they're not entitled to the insurance benefits. And what we know is that totally disabled is a term that's defined in the policy. It is a legal term. It's not the way that we use it colloquially. And so you shouldn't be relying on your doctors for legal advice. You rely on your doctors for medical advice. The same way, I don't give my clients any medical advice at all. I always say, talk to your doctor. Or you see someone might go to a lawyer, but it's someone who doesn't have experience dealing with disability claims. And disability claims are a very particular field. You need to have experience in order to understand exactly what's going on and exactly why insurance companies are acting the way they do. If you don't have experience, you may not understand exactly what's happening. And so we see this quite often when someone has a lawyer that they've used for a family law issue or a criminal issue or just any other civil issue that doesn't have to do with disability law, and they'll say, okay, well, you know, Jerry was great for me on that other case. I'll just go back to him and see if he can handle it. And sure enough, Jerry will say, okay, yeah, I can do this. Why not? And they'll take a look at it and they think they know what they're doing. And they'll say, oh, well, let me help you with this appeal, which we're going to get to in a moment. But when you have a lawyer that doesn't have experience dealing with disability issues, mistakes are very frequently made. So you have to be careful. Or sometimes people will just rely on, you know, a friend, a buddy that they have, or a family member that thinks that they know what they're talking about, but has never done this from the legal side of it. And you got to be very careful. But the good news is that if you're worried that the information you're getting isn't correct, there's an easy way around that. You give us a call. It's 100% free. No one's going to take a credit card. You give us a call, ask whatever questions that you have, and you'll get the answers. You don't have to start a claim to get the information either.
And you mentioned it, 1-855-821-5900 is that number, just in case you didn't see it at the bottom of the screen. The three mistakes people make when denied LTD, well, you brought it up. Number two is the A word, always is. They appeal that denial.
Yeah, and I know we've already talked about this, but it's worth talking about again. The appeal is an internal process. And so when you get that denial letter or the letter that's cutting off your benefits and you see, oh no, my benefits aren't coming in anymore, but you get to the bottom of the letter and it's saying, well, here's a light at the end of the tunnel for you. All you have to do is bring this appeal and maybe we'll just reconsider. That's what they want you to feel like. The insurance company wants you to feel like, well, it's not all over yet. You can still keep going through the process and, you know, we'll continue to look at it. And if you want to provide us some new information, that's great. The reality is, though, if your insurance company already has the information from your doctors, if they already understand what your doctor's opinion is and you've been providing them with updated records, they're not going to change their mind. I see this every single time someone appeals. They get their family doctor or their treating doctor to write a letter to the insurer saying, why have you denied my client? He really is or she really is disabled. Maybe you don't understand what my records mean. And it's not that they don't understand. They understand. They've just made a decision that they would prefer not to keep paying you benefits. And they found whatever justification that they're relying on to use for that purpose. Doesn't mean that they're correct, but it does mean that continuing to appeal isn't going to get you anywhere. The only way to change that is to start a legal claim.
And then the appeals stop because you guys are involved, and it's all over from there, right? As far as the client is concerned, they don't get bothered anymore as well.
No, that's right. As soon as they were retained, the insurance company is no longer able to contact our clients, and they can just focus on their treatment and rehabilitation.
Third reason is this, James. They just accept the insurance company's decision. Okay, I guess they know best. They're the big bad insurance company. How would I know?
Yeah, I think that's the way a lot of people feel. Most people have never been through this process before, and they're dealing with a large billion-dollar corporation that deals with this day in and day out. And you know, even if they have the support of their doctors, it feels kind of hopeless. It's a David and Goliath situation, and they don't really know where to turn or what to do. And they figure, well, if this is what the insurance company is saying, it's almost like it's being handed down from God. Well, I'm here to tell you, it's not handed down from God. If you have the support of your family doctor, your treating doctors saying that you are not able to go back to work, then your insurance company's wrong if they cut you off. It's as simple as that. If you start a legal claim, they're going to start being reasonable very, very quickly.
Coming up, this question: should you appeal an LTD appeal, or should you appeal the denial if you've missed the deadline? What do? Do you sit back or do you tackle it? We'll find out after a short break. 1-855-821-5900. Email is help@disabilityrights.ca.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Disability Law Show. You want to reach out anytime. It goes across the bottom of the screen, but give it to you anyway. 1-855-821-5900. help@disabilityrights.ca is the email address we use each week, and the website is disabilityrights.ca as well. James, this one, first email of the show is coming from our pal Dennis. Dennis says, my brother suffers from major depression, anxiety, and a phobia that prevents him from spending time out in public. He sees a psychiatrist and takes medication. His insurance company said that they're cutting him off long-term disability after 2.5 years because they claim to have surveillance showing him helping me move into a new apartment. What can we do?
All right, well, let me address what is probably the biggest issue in this email, and the one that's probably going to get the attention of most of our viewers, and that's the surveillance aspect here.
Right.
So surveillance is an insurance company hiring a private investigator to follow around someone who is either applied for or who is in fact receiving disability benefits, because they believe in those circumstances that they're going to be able to discover that this person is really making it up, that they're malingering in some way, that they're able to do things that they say that they aren't able to do. And occasionally they're right. I'm not telling you that there's never been surveillance where an investigator has found someone who says that they can't get out of bed going and playing a game of pickup basketball with their friends. Well, if that happens, if you're telling people that you can't get out of bed and they see you active, the insurance company would be very justified in those circumstances in cutting off or denying your claim. But that's not what we're talking about here. As long as you are being honest with your doctors and you're being honest with your claims handler when they call you, you have absolutely nothing to worry about when it comes to surveillance. So here's what I mean. Let's say, for example, that you have some sort of a physical impairment and your doctor says, well, the best thing for you is to go to the local pool when it would be safe to do so and swim for an hour a day or an hour a week. So, just go and make sure that you have a membership and go do your swimming on a weekly basis. And when your adjuster calls, you tell them that. Well, if they go and if the insurance company goes and hires an investigator to follow you around, and they see that every week you go to the local pool and you have your gym bag with you and you come out and your hair's wet and it suggests that you've been going swimming for that hour, as long as that's what your doctor's recommending and you've been honest about it all the way through, it doesn't matter. It's not really showing them anything that's of any benefit to them at all. It's just doing exactly what's been recommended and what you've told them. That's not uncovering anything. And in this particular case, what Dennis is talking about here, I think is very similar. So Dennis's brother is suffering from mental health issues, depression and anxiety. There is nothing about depression and anxiety that would prevent him from helping his brother move. It doesn't make any sense to me. The reality is there are very few situations I can think of when someone's suffering from depression and anxiety where surveillance is going to be the least bit helpful. I mean, I suppose you can imagine a scenario where, someone is out going to dance clubs every night and is just hanging out with their friends all day, and you might come to the conclusion that they're not depressed or suffering from anxiety. I suppose that's a possible scenario, but that's someone who is clearly being fraudulent, who's clearly trying to game the system. But for most people that are legitimately suffering from depression or anxiety, what is it you expect you're going to be able to find on surveillance that is going to refute that they are legitimately suffering from these conditions? I mean, it's certainly not helping a family member move. That makes no sense to me. What does that have to do with being depressed or being anxious? It's got absolutely nothing to do with it at all. And so if an insurance company is using this as a justification for denying benefits, it's clear that they've just made the decision and they're using whatever justification they can, and this is just simply the best one they've been able to come up with. And what that says to me is that they're in a really bad position, and you start a legal claim and they're going to pay up. Simple as that.
Plus, I mean, Dennis's brother's doctors may see this, and it may rightly so, that going out and helping his brother may help his mental condition. So it's actually therapy. It's not hindering. It's no need to cut him off, right?
Yeah, I mean, listen, I don't want to start giving out medical advice here. That's not my job as a lawyer. But I can certainly say in my experience dealing with mental health claims, which are probably 60 to 70% of the long-term disability claims that I'm handling, it is almost always the case that doctors are explicitly recommending to their patients that they should be as social as they're able to be. That going out there and being social is, in fact, good therapy for them. Now, again, that is not, that's not medical advice coming from me. This is just what I've observed in files. And you shouldn't rely on that for medical advice. Rely on your doctors, rely on your therapist for sure. But it's certainly very likely that this isn't something that a doctor is going to say, oh no, that's going to set you off, that's wrong, or that's inappropriate for you to have been doing. And I can't imagine that the insurer has their own doctor that is going to take a look at that surveillance and support that decision by saying, well, clearly he doesn't have depression or anxiety. That makes just no sense to me. I can't imagine any doctor or psychologist is going to support that kind of a view.
When it comes to surveillance and the insurance company, I got to assume, I don't know, I got to assume that doesn't come cheap for any insurance company to pay for surveillance, whether it's hours, few days, few weeks. Aren't they not going to want to try to get something out of it if they paid for it? You know what I mean?
Yeah, that's a very good point, John. So whenever you see an insurance company spending more money than they need to, in other words, $1 more than what's required to pay for the benefits, right, you can believe that it means that they are trying to find a way to justify denying or cutting off benefits. And so if they're hiring someone, an investigator, to do surveillance of you, you're right, John. I mean, typically, even if they're being a little bit cheap about it, they're going to be spending $5,000, $6,000 on it. They're not cheap. And I've seen some cases where they've gotten 10, 12, 13 days worth of surveillance and are paying upwards of $10,000 to have people followed around all day long for a week or so at a time, and they find almost nothing. And so what they have to do is justify spending that kind of money. And it's situations like this where you see, well, they don't really uncover anything because really there's nothing to uncover. So they say, okay, well, he was out moving with his brother. We'll just use that. That's almost certainly what's happened here. I mean, obviously, I'd have to take a look at the file to be sure. But if that is what they're using as a justification, I would guess that they probably spent several $1,000s trying to come up with something and came up blank. So they're just using this as an excuse, really, to justify a decision that they probably had already made.
Email address again, help@disabilityrights.ca. This one is from Selena. Says, my 58-year-old father suffered a stroke last year. Because of everything we've been dealing with, we've missed the time for applying for LTD by 10 days, and the insurer denied his claim because of that. His wife, who is disabled herself, is left with very little income. Should we appeal?
Well, John, I'm actually going to surprise you a little bit here. So this is going to be my one exception to the never appeal. And I'm going to explain why. So I got to be very careful about this because my advice is almost always never appeal. And frankly, even if you didn't in this case, it would be fine. But there are two different deadlines that you have to be aware of if you're in the long-term disability process. The first is the deadline for making an application, and that's what we're dealing with here. If you've missed a deadline for applying for your benefits, that is something that there is a remedy for. It's called relief from forfeiture, and the insurers are well aware that this is something that is out there. So if you miss a deadline for applying, you become disabled, you're off work, there's usually a deadline of something like 90 days to apply for these benefits. If you've missed that deadline, your insurer still really has to process your claim if you have any kind of an excuse for it. And that's just what the courts have been saying. After a certain amount of time, they'll be justified in rejecting it. If it goes a year, 2 years, you might be in trouble. But if you've missed it by 10 days, they know that they're going to have to process that application. Now, don't take that as license to miss the deadline. I would strongly encourage everyone to apply within the time frame that's set out in the policy. But if you've missed it, there's a remedy for that, and the insurer is aware of it. So if they've rejected it in this particular case, I would suggest actually appealing it and saying, listen, I missed a deadline by 10 days. I'm aware that you're required to process the claim anyway because you have to give me relief from forfeiture. Use that phrase, relief from forfeiture. Put it right in front of them. They may well deny the appeal. It's possible that that won't get you anywhere and you're still going to have to bring a legal claim. But if you've used that phrase with them, if you've put it right in front of them that they're required to do that, this is what the courts are saying, relief from forfeiture, you have to process the application, and they still deny that appeal, now they're really exposing themselves to something beyond just the benefits they owe you, because now they're just ignoring what the courts have told them that they have to do. So this is the one very narrow exception, I would say, in that particular circumstance. It is worth appealing one time and one time only by using that phrase, relief from forfeiture, by saying, listen, I've applied, I was 10 days late, you have to process my application. But the other thing I do want to clarify here is there are two different deadlines that we talk about in the context of long-term disability claims. So the first one we've just been talking about is a deadline for applying. And so that is the one where if you're a little bit late, and in this case, 10 days late, it is something that that can be cured by this relief from forfeiture that we've been talking about. But the other deadline is a deadline for starting a legal claim. That is a 2-year deadline, and the clock for that starts running as soon as you get the first denial letter from your insurance company. That deadline, there's no way getting around that. If you miss that 2-year window and you don't start your legal claim within 2 years of getting that initial denial, sorry, you're out of luck. There's no way around that. So please make sure in both cases that you are within the time frame that's set out in the policy or within the law, the 2-year limitation period.
Let's get Chris's email in here quick, James. Goes like this. Chris says, I'm 57, have been off work for nearly 2 years due to back and hip issues. I've undergone lots of different treatment, but I'm at a point where I need back surgery. Due to COVID, my surgery is not scheduled until next year. My surgeon tells me there will be months of recovery after that, but my insurance company is cutting me off next month at the 2-year mark. They say I can work a sedentary or light-duty job instead. Can you help me?
Yeah, absolutely. So let's just talk about this 2-year mark and what it really means. So when you have a long-term disability claim and you're approved for benefits, in the first 2 years, you're entitled to continue receiving benefits as long as you are continuously disabled from your own occupation. After 2 years, that test changes, and it's whether you can do any occupation that you're qualified for by training, education, or experience. And so it is a tougher test to pass after that 2-year mark. There's no doubt about that. And there are going to be situations where the insurance company will be justified at the 2-year mark in cutting someone off. Now, whether or not in this particular case, whether or not they're justified in denying Chris at the 2-year mark is an open question. But it suggests, what Chris has written, suggests that they're probably wrong in this case, given the issues that he's having and the fact that he's going to require surgery in the future. Unless Chris has, the ability to do a job and make at least 60% or 65% of what he had been making, working perhaps part-time with considerable pain, who knows what his functional limitations are, then the insurance company isn't going to be justified. And that's really where this analysis comes down to, is what he's going to be able to earn, at least in the immediate future. It's possible that after the surgery, he might be okay to either return to his old job or perhaps to some sedentary position where he would be able to make that commensurate income, making 60%, 65% of what he had been making before. But until that happens, it seems really unlikely to me that the insurance company is going to be justified in taking that position, whether or not it's after that 2-year change of definition mark. I'd have to, of course, take a look at the file in detail in order to be certain of it. But based on what Chris has written here, I think it's absolutely a case that could be challenged, and probably pretty easily.
Yeah, you're not going to have a neurosurgeon being a greeter at a very large retailer. That's not commensurate income, I would imagine.
No, absolutely not. You have to be able to make essentially what your insurance company is paying you in benefits. If you can't replace that, you're going to be entitled to continue receiving.
Chris, reach out further if you want. The phone number 1-855-821-5900. You know the email address, help@disabilityrights.ca. And the website with tons more information and more ways to reach out is disabilityrights.ca. Thanks for joining us on this edition of the Disability Law Show. We'll catch you next time.